Good afternoon, everyone. I'd like you to welcome you all to the Sheriff's Office webinar. Today we will be covering the rapid eviction of tenants from a residential property, and we have our guest speaker Matt Carter here today, and he is a business development manager at the Sheriff's Office. Welcome, Matt.
Okay.
And we have Yezdan Isit, and she is partner and head of real estate disputes at Bolt Burden. I'm just going to let you all know now that we will be distributing these slides along with a recording of the webinar tomorrow afternoon at approximately 12:30. You should receive those on an email, so yes, don't worry, you'll be receiving them. Okay, let me run through a quick technical tour. The webinar dashboard can be minimised or maximised by clicking the white arrow, and you may ask questions throughout the webinar. We will try and address as many of these as possible, but I know that we have quite a few of you attending the webinar today, and we will be distributing the webinar questions and answers on a series of articles that will be sent out via the Sheriff's Office newsletter over the coming weeks. Let me just run through the legal disclaimer. Please treat the contents of this webinar as food for thought, but don't take any action based on its content unless you have taken legal advice. The speakers today cannot accept responsibility for any errors or inaccuracies, loss or damage, unless we have given you personally specific advice relating to a matter about which you have given us full background details. You must also bear in mind that the contents of this webinar are based on English law, and because it contains archival material, that material is bound to go out of date at some point. The aim of this webinar is to provide a sufficient understanding to landlords of how to terminate an assured short-hold tenancy agreement and evict tenants using High Court enforcement under Section 42 of the County Court Act 1984 and the relevant forms to transfer up to the High Court for enforcement purposes. I'd like to hand over today to Yez, who will be covering the first part of this webinar.
Hi everyone. So firstly, thank you to the Sheriff's Office for inviting me along today. It's a pleasure to be here. I'm a partner at Bolt Burden, and we are a firm of solicitors based in Islington in North London, and I head up the real estate disputes team, specialising in property-related disputes, including landlord and tenant issues arising in connection with rented properties. I'm going to start by taking you through the relevant notices that you need to serve in order to recover possession. So I'll speak to you about Section 8 notices, Section 21, a little bit about service, and then I'll hand you over to Matt to talk to you about transfers to the High Court. So firstly, it's important to mention from the outset that there are various types of residential tenancies, and it's important to know the difference, as this will often affect the extent of the tenant's rights in the property and the landlord's options when it comes to dealing with certain issues such as rent increases or termination. For the purposes of this talk, we are focusing purely on assured short-hold tenancies, which I'll refer to as ASTs throughout the talk. And we will mainly be talking about tenancies in England. For tenancies granted after February 1997, the default position is that it's likely to be an AST unless the tenancy falls within certain exclusions which are specifically set out in Schedule 1 of the Housing Act 88. And the most common exclusions that you'll come across are high rental value properties, say where the rent is more than $100,000 per annum, where there might be a resident landlord, or company let. So if your tenancy is to a company, irrespective of whether or not it's a residential property or not, it won't be an AST, it's more likely to be a contractual tenancy. It's best to get advice as to what type of tenancy you're dealing with from the outset, particularly if you're in the process of purchasing a property subject to an existing tenancy. It's good to know what your tenants' rights are, and especially if you're dealing with much older tenancies, it might be virtually impossible to evict them. So we'll start by talking about Section 8. So there are generally two routes to obtaining possession of your property. The Section 8 notice is where you are relying on some breach of the tenancy by your tenant, or alternatively a Section 21 notice, which is essentially a no-fault route to possession. Dealing with Section 8 notices first, generally you can't terminate a tenancy during the fixed term unless there is a break clause entitling you to do so, or there is a breach by the tenant. Even if you have a situation where there is a breach by the tenant, there must be an express provision in the agreement which allows you to terminate the tenancy because of that particular breach. This is often referred to as a forfeiture clause, and typically you can find it in the provisos section of an agreement, and there will usually just be a clause that simply states something along the lines of re-entry is permitted by the landlord in the event of a breach. Assured tenancies are governed by the Housing Act 1988, and the various statutory grounds on which a landlord can rely upon in order to terminate using the Section 8 procedure is set out in Schedule 2, and I've attached a link there. Hopefully that's working. It's probably worth having a quick look at the various grounds. Grounds 1 to 8 are mandatory, which means that if those grounds are satisfied, the court must make an order for possession. In order to rely on grounds 1 to 5 of those mandatory grounds, the landlord must have given the tenant written notice before the tenancy was entered into that they want to regain possession on those grounds in future. Just to give you an example, so grounds 1 and 2 relate to the landlord wanting to occupy the property as its own residence, or if the landlord's got a mortgage, just warning the tenant that a mortgagee might want to take possession at a future date. So grounds 1 to 8 are mandatory. Grounds 9 to 17 are discretionary grounds, meaning that the landlord must convince the court to make the order, but the court is not obliged to do so. The most common ground relied upon is rent arrears, and ground 8 is the mandatory ground for rent arrears. The amount of rent arrears required in order to rely on ground 8 will depend on the frequency on which the rent is paid under the tenancy agreement. So for instance, if it's paid weekly, then you need at least 8 weeks arrears. If monthly, you need at least 2 months rent unpaid. And if paid quarterly under the tenancy agreement, you need at least 3 months arrears. Now, because ground 8 is mandatory, provided you can show the court that the requisite amount of rent is outstanding at the date of the hearing, then the court must make the order for possession. Your Section 8 notice will need to specify all the grounds that you intend to rely upon. So it's important that you put all the relevant grounds in the notice at the outset, because you won't be able to rely on any other grounds once you get to court. It is usual when you are relying on the mandatory ground 8 that you would also cite discretionary grounds 10 and 11. That is that there might be some arrears owing, or that there has been persistent delay in paying rent by the tenant. The reason for that is because a little clever tactic employed by some tenants is that if you say, for instance, that if you need 2 months rent outstanding in order to rely on ground 8, and by the time of the hearing, the tenant pays some of the arrears, which reduces it down below the 2 months required, then you can no longer rely on the mandatory ground and you're left to rely on the discretionary ground. In reality, in my experience, courts are reluctant to give possession on a discretionary ground alone, so I'd be reluctant to use Section 8 as a route to possession if my client has another option. The notice period under Section 8 will depend on the ground you're relying on. Rent arrears is usually 2 weeks, which is a much shorter notice period than Section 21, which I'll come on to shortly. There is a prescribed form for Section 8, which you must use, otherwise your notice could be invalid, and again I've attached a link to the prescribed form from the government website. Once the notice period expires, if the tenant hasn't made the payment or corrected the breach, whatever it might be, then you can issue your county court claim for possession. Your notice is usually valid for a period of 12 months, so if you don't issue in that time, you'll have to serve a fresh notice. You can use the possession claims online for rent arrears claims, or alternatively, you can make a paper application to the court. So typically, on receipt of the claim form, the court will list a hearing within 8 weeks. The downside of a Section 8 notice is that the tenant could raise a defence or a counterclaim. The most common counterclaims are those in relation to disrepair, or for instance, if the tenant paid a deposit and it wasn't properly protected, then the tenant might be able to apply for a penalty, and the effect of a counterclaim would be to reduce the amount of the arrears that are due, and that could potentially be offset against your rent. If a defence is raised, then court proceedings can very quickly become lengthy and protracted, and usually the court will adjourn the first hearing and list directions, which is essentially a timetable setting out the various steps that you need to take in order to progress the matter to a full trial and deal with all the issues that are raised in the claim between the parties. I think that's all I'm going to say about Section 8 for now. We'll move on to Section 21. Section 21 is a bit of a minefield and has undergone so many changes in the last couple of years. I've been doing this talk with the Sheriff's Office for, I think, the third year in a row. And I've had to keep updating my talks because it's just ever changing. And the way that I've tried to do this today is to create a little bit of a checklist of all the things that you need to look out for when you're dealing with a Section 21. So Section 21 is a no-fault route to possession. AST tenants don't have security of tenure, which means that once the fixed term of the tenancy has come to an end, the landlord can take steps to terminate the tenancy by simply serving a 2-month Section 21 notice requiring them to vacate. There are proposals for substantial reform of the Section 21 process, but the procedure set out in this talk is what applies for now. The Deregulation Act, which I'm sure you've all heard lots about, introduced new rules in relation to the way in which tenancies of properties in England can be terminated and which restrict the landlord's ability to serve a Section 21 notice. I do need to highlight that this doesn't apply to tenancies in Wales. From the 1st of October 2018, from last year, the Deregulation Act's provisions apply to all assured short-hold tenancies, irrespective of when they were granted, so even if they were granted prior to the Act coming into force. Now, although Section 21 is a no-fault route to possession, there are a number of hurdles that a landlord needs to overcome to serve a valid notice, and I'll talk you through those now. So, still on this one now. The notice firstly needs to be in prescribed form, and I have attached a link to Form 6A. Hopefully that's working. Form 6A contains a bit of a checklist, which is worth looking at actually when you grant the tenancy, because what the notice sets out is all the things that you need to have done in order for that notice to be valid, so it is worth looking at when you're granting a tenancy. The minimum notice period required is 2 months, and your notice no longer has to expire on a particular day. In order to be able to serve a Section 21 notice, you need to wait at least 4 months into the tenancy. In the case of a renewed tenancy, that 4 months will start from the term of the original tenancy. It used to be the case that a landlord could serve a Section 21 notice at the very start of a tenancy, and quite often what they would have done is just attach it to the tenancy agreement at the outset, warning the tenant that they'll be relying on that notice when the fixed term comes to an end, even if that fixed term was 12 months later. You can't do that anymore. You need to serve a notice. You can't serve a notice unless you're at least 4 months into the tenancy, and tenancy Section 21 notices now only have a lifespan of 6 months. So if you don't issue county court proceedings for possession in that time, you've got to reserve a fresh Section 21 notice. At the start of the tenancy, landlords must have given the tenants a gas safety certificate with a date within 12 months, a government booklet on how to rent, which you can find online, and an energy performance certificate for the property, failing which you can't serve a Section 21 notice. In addition, thanks to the Deregulation Act, we've got to deal with retaliatory eviction. The purpose of this is to prevent rogue landlords from taking retaliatory eviction against tenants and give some security to tenants who might otherwise feel unable to complain about poor conditions of their property. So in short, if a landlord is served with an improvement notice or any other relevant notice from the council concerning the state of the condition of the property, or the tenant so much as even makes a whiff of a complaint, but it's a legitimate complaint to the landlord about the condition of the property, and the landlord doesn't provide an adequate response within 14 days, that landlord won't be able to serve a Section 21 notice until the disrepair issues have been properly addressed. There are some limited exceptions. So, for instance, if the tenant is in breach of the tenancy, or against social landlords, or where the property is genuinely being marketed for sale. The wonderful world of tenancy deposits. So this is another barrier for recovering possession if it's not been properly dealt with at the outset. So as most of us will know, any deposit taken in connection with an AST since April 2007 must be protected, and a tenant must be served with prescribed information within a period of 30 days from receipt. Purpose is twofold: firstly, to protect the tenant's deposit, and secondly, to deal with any disputes between the landlord and tenant. There are only 3 authorised providers, and I've attached a little link which will contain some further information about that. The providers are My Deposit, the Tenancy Deposit Scheme, and the Deposit Protection Service. Consequences of failing to register the deposit on time are that you can't serve a valid Section 21 notice until you have returned the deposit in full to the tenant. Also, your tenant can apply to the court for payment of a penalty. So if it's proved at court that it wasn't registered in time and the prescribed information wasn't served, then the court must make an order, and the amount of the order is usually once, twice or 3 times the deposit amount. For a little while there was a lot of confusion as to how to go about dealing with deposits where the landlord failed to comply at the outset or when dealing with a renewal tenancy, but the Deregulation Act has clarified the position to some extent. So the position now is that if the landlord takes a deposit after April 2007 and complies with the initial requirement, there's no need to re-register that deposit on a renewal tenancy. If the tenancy is an old tenancy now, so entered into before April 2007, then there's no need to, at which point there was no need to register the deposit, then there's no need to register the deposit, but just be aware that you can't serve a Section 21 notice if you are holding an unregistered deposit. Although there won't be a penalty, you'll need to return that deposit in order to be able to serve a Section 21 on a tenant. So how best to deal with a deposit when it's not been protected? Best practice is to return it. It's no longer the case that you can register it late. If the deposit was protected, but the prescribed information wasn't served, then you need to serve that prescribed information. Otherwise, consider all of your other options. Is there a breach? Can the landlord serve a Section 8 notice instead? Because tenancy deposits are not a bar to dealing with Section 8. Or otherwise, can you offer the tenant some kind of financial benefit for an early surrender of the tenancy, if that's going to be an easier option for you? It's worth mentioning that if your property requires a special licence before you can let it out, this could also prevent you from serving a Section 21 notice. So have a word or look online to see what your local authority's requirements are, particularly in relation to houses of multiple occupation, and also to see if your particular local authority requires a selective licence, because unless you've got those licences in place, you won't be able to serve a Section 21 notice to recover possession. The Tenant Fees Act is the most recent act that's come into force, which affects Section 21 notices, because again, if you're not compliant with the Act, you can't serve a valid Section 21. The Act restricts what landlords and letting agents can charge residential tenants, so this doesn't apply just to ASTs. At the moment, it applies to all tenancies that were granted after the 1st of June 2019, but from next year it will apply to all existing residential tenancies from the 1st of June 2020, so it's going to have a bit of a retrospective effect. Some of the charges which have traditionally been passed on to tenants under a tenancy agreement will now be prohibited. So just to give you a bit of an example, so inventory, check-in and check-out fees, viewing fees, cleaning costs, credit checks, or any other costs associated with setting up the tenancy can no longer be passed from the landlord to the tenant under the tenancy agreement. You'll be pleased to know that the Act still allows you to charge your tenants rent. It also still allows you to ask for a rent deposit, although this is now subject to a cap, and the cap is 5 weeks if the rent is less than $50,000 per annum, and 6 weeks if the rent is more. It also allows you to charge a repayable holding or reservation deposit, although that's also subject to a cap, and some other charges, so utilities, council tax, fees in relation to where costs might be incurred where a tenant might be in breach. So there are certain things that you can recover. If the tenancy was entered into before June 2019, so this year, at the moment, agents and landlords can still continue to require the tenant to pay the fees that are set out in a tenancy agreement, but that's only until the 31st of May next year. After the 1st of June next year, any terms in the tenancy agreement requiring the tenant to make what are being referred to as prohibited payments won't be binding. And if the tenant is asked to make a payment in error, that payment will need to be returned to the tenant within 28 days to avoid being treated as having requested a prohibited payment. A breach of these fees ban is quite serious. Initially, it will be a civil offence with a financial penalty of up to £5,000 per demand for a prohibited payment. And if it's a second offence, the compensation could be up to £30,000, and in addition, it's going to be a criminal liability. So once you're satisfied that you've prepared what you're entitled to possession on a Section 8 or a Section 21, you need to ensure that you serve the notice properly. The starting point is to check the terms of the tenancy agreement. If the tenancy agreement specifies what method of service is required, then you must follow that. So, for instance, if the tenancy agreement says that it needs to be personal service, and then you post that notice is going to be invalid. If the tenancy agreement is completely silent, you can rely on Section 196 of the Law of Property Act. I think there's a typo there, I should say 1925. Then the notice can be left at the last known address or the property address and can be sent by registered post unless it's not returned undelivered. We often take a belt and braces approach and serve it by every means possible. Make sure when you serve a notice, be that Section 8 or Section 21, that as well as the 2 weeks or 2 months, whatever the period might be, period of notice required, that you also add a few extra days on for service. Last thing you want to do is to get to court having ticked all your other boxes and find that you haven't given sufficient notice because you might be out by a day or two. And that does happen. And if that happens, you've got to start the process all over again and serve a fresh notice. So the last bit for me is the claim forms to use. So again, once you're satisfied that you've served a valid Section 8, a valid Section 21, whichever the case might be, and you're also satisfied that you've complied with the service provisions, if the tenant fails to leave the property or they don't remedy the breach, then you will need to issue county court proceedings to recover possession. You can't go in and simply change the locks on a residential property because the tenants are afforded protection under the Protection from Eviction Act 1977. You can use the possession claims online for rent arrears only. Alternatively, you need to use the paper applications. So the N5 and the N119 are the ordinary possession procedure. You just need to make sure that once the forms are filled out, that it's submitted to the local county court serving the area in which the property is based. There have been a number of court closures over the last few years, so just check with your court before you issue that the claim can be issued there. And once the claim is issued, it's usually listed for a hearing within 8 weeks of receipt by the court. Alternatively, if you're relying on a Section 21 and you are able to tick all the boxes and you also have all your documents that the form requires you to have at hand, then you can use the accelerated possession procedure, and the claim form for that is the N5B. The accelerated procedure is a little bit different in that the court won't list it for a hearing. The court will usually deal with it by paper unless it, for some reason, it requires the attendance of the parties or further evidence. When you apply for a possession order, it's good practice to request the leave of the court to transfer to the matter of the High Court for enforcement purposes using Section 42 of the County Courts Act 1984. At the hearing, if you are successful in getting your possession order, the order will usually require the tenant to leave the property within 14 days or any other period up to 6 weeks if the tenant can show exceptional hardship. I always reiterate the request for permission to transfer the matter to the High Court for enforcement purposes. In my experience, especially in the last couple of years, judges are reluctant to grant this, but I find that they can be persuaded, particularly if your client has waited a long time to get to that possession hearing, or there's going to be a further wait because the tenant has convinced the court to allow further time in order to vacate the property. If at the end of the period set out in the possession order the tenant still doesn't vacate the property, then you will need to enforce the possession order using either the county court bailiff, which typically has a delay of around 8 weeks, or by using high court enforcement. And on that note, I'm going to hand you back.
Thanks, Yez. Really useful stuff there. You certainly know your legislation. We're going to have a quick learning review. Bear with me 1 second while I just launch the first poll question. So the first question, Section 8 is used for A, breach of tenancy, or B, a no-fault possession. And brilliant, that's great. Most of you have got that as a breach of tenancy, which is the correct answer. Since October 2018, landlords are legally required to provide which of the following: a gas safety certificate dated within the last 12 months, how to rent booklet, energy performance certificate, or all of the above. Again, it's all of the above. That is the correct answer for that question. And our next question, what can affect a landlord's ability to serve a Section 21 notice? Failing to register a deposit on time, failing to respond to requests for repairs within 14 days, or all of the above? Correct answer there is all of the above. And the final question, PCOL, possession claim online, can be used for which of the following? Eviction notice, rental arrears, or damage to property? Okay, and the answer to that one is, in fact, just the rental arrears, so the cash value that you're claiming in rental arrears. Okay, Matt, over to you.
Thank you very much. And thanks, yes, some great guidance there. And for getting us to a point where you can actually start to think about the eviction and the enforcement of your possession order. Just to give you a brief sort of overview of High Court enforcement in general, we, as the Sheriff's Office, and we're no different to any other High Court enforcement company, have to have an authorised High Court enforcement officer or an authorised officer as part of our company in order to operate. They are licensed and authorised by the High Court and Ministry of Justice. We are regulated by the Ministry of Justice, and our authorised officer is David Asker. His name's on the writ, and it's down to that authorisation that we can operate and enforce various types of writs. Our jurisdiction is England and Wales, so for possession, the property would need to be within England and Wales. If it's on the debt side of things, the defendant doesn't always have to be residing in England and Wales as long as there's some assets. If you've got queries north of the border, the law's slightly different in Scotland, but we do have partners, so any inquiries regarding sort of Scottish judgments or possessions, please do send them in. So the various types of writs that we can execute, most commonly a High Court writ of control, and it's going to be for the recovery of money. Any judgment or order £600 or over can be transferred up to a High Court writ of control. It's a cost-effective, quick way of trying to recover that judgment debt. £66 for the writ. The only other fee is a compliance and abortive fee at the back end if we're unsuccessful, for whatever reason, of £75 plus VAT. All judgments made within the High Court can be transferred across to a High Court writ of control, and all employment tribunal awards, ACAS or otherwise, can also be transferred up to a High Court writ of control in order to attempt recovery of that money. A different type of writ is a writ of delivery, which is for specific items. So the item would be named on the order, we transfer it up to a writ of delivery, and we enforce to actually recover those said specific items. And more relevant, more importantly for this webinar, writs of possession, which could be against a mortgagor. Normally, claimant would be the mortgagee, the lender. Tenanted properties, which we're going to go into more detail here today, and potentially trespassers, persons unknown, or even just the repossession of land would be covered with a writ of possession. So we're going to focus quite heavily on Section 42, which was mentioned by Yez in the build-up to getting on to enforcement, because Section 42 is crucial as to whether you can use High Court enforcement or not. If Section 42, which is basically permission to transfer to the High Court, as per Section 42 of the County Courts Act 1984, doesn't appear on your order, then unfortunately you're going to have to go down the County Court bailiff route, and you won't be able to use High Court enforcement. So the best way to apply for Section 42 is at the outset of when you're applying for your original possession order. There are mitigating factors, reasons for the application that we'll go to on the next slide, but you state your case. It doesn't cost you anything. It is down to the judge's discretion as to whether they grant you Section 42, permission to transfer to the High Court. If they do, great. If they don't, you haven't lost out on anything financially. The other way to apply is retrospectively if you've already got a possession order and you decide now that perhaps you would like the High Court to enforce that as a writ of possession, you would use a court form N244, complete that and submit it back to the court that the possession order was issued, requesting Section 42, again with your reasons as to why you're applying for it. There is a £100 court fee attached to that. It is down to the judge's discretion. So unfortunately, if they wanted to keep it in-house and didn't grant you permission to transfer, then you would have lost that £100. So making your application for Section 42, the main reasons you would want to use High Court enforcement for your eviction is going to be timescale. You're probably aware, you will have come across it at some point, the directive from government has been for a long time, down to local government, housing association, citizens advice bureau, advice to the tenant is stay put until you're evicted. So more often than not, you're going to need the county court bailiffs or the High Court enforcement. So if we can save you time and money by evicting via the High Court, then you're going to want to apply for Section 42. So one of the first reasons is going to be the county court bailiff delay, the lead time, how long you've got to wait, 8, 10, sometimes 12 weeks in places like London and the Midlands, which causes a loss of income for you as a landlord, causes hardship to go another 3 months without rent. So that's the main reason. That's not always enough to sway a judge to grant Section 42. So there are other mitigating factors that you can add to your reasons why you're applying for it. Always let the judge know that you are going to give notice to the tenant that there is going to be an eviction, because it's good practice and they like to see this. Let them know that you, or if it's your client, the landlord, is responsible for the eviction costs. There'll be no more financial burden upon the tenant who probably is already suffering financially. If your tenant is causing antisocial behaviour, damage to the property, criminal damage, you'll have some documentation of that. That's a short way of getting Section 42 granted, and you would include that in your application. Another quite clever way, really, is if you've gone down the Section 8 route and you've included rental arrears, and they total over £5,000, the county court bailiffs can't recover that anyway. Anything over £5,000 has to go to High Court. So you would include that information and state that you would like the possession carried out as per the rent arrears via the High Court. It is down to the judge's discretion, but we do, here at the Sheriff's Office, assist you with the draft order, with inputting that while you're applying for your original possession order. Like I say, the other way is retrospectively, you would do all of those things. You would just put it on an N24 application notice, send it back to the issuing office with the possession order, and request that Section 42, permission to transfer to the High Court, is granted. So we'll sort of jump to a point now where you've got a possession order and Section 42 has been granted, and it appears on that order or on a slightly separate order if you applied for it retrospectively. How do you obtain the writ? Well, you don't. We'll do that for you. However, there are a few court forms, and don't be too taken back by those court forms listed in front of you now, because like anything, once you've done it a couple of times, you'll know what you're doing, but we also hold your hand through the process and pre-complete as much of the court forms as possible. You pretty much end up just completing the particulars of the case. But the process is as follows. You need to complete an N244 application notice, a copy of which is served upon your tenant, stating that you are applying for permission to issue a writ. It carries a £100 court fee. That's just the way it is. You then sign an N215 certificate of service, stating that you have served that N244, a copy of, upon your tenant. Then you either complete a PF88 or a PF89, depending on whether there's money attached, and you will send those back over to us. We typically have a look, check that they've been completed correctly, and assist with getting those completed correctly. We then fill out the PF92, which is a vehicle to completing the number 66 writ of possession, which we would get sealed for you. The writ does carry a £66 court fee. So for tenanted cases, you will be looking at £166 disbursements to the court in court fees for going down that route. Like I say, we do assist you with completing those forms. That process only takes a matter of days. So just to let you know, if it was a trespasser, you don't have to issue the N244 or complete the 215. Same if it was a mortgagor. If it was either of those, you don't need section 42 either, just to be aware. So we'll have a slightly closer look now at rent arrears and getting you thinking about outstanding monies. If you've got section 21 and you did want to pursue the tenant defendant for outstanding rent arrears, then you would and are able to make a separate claim via a county court judgment, either money claim online, do it yourself, or via a solicitor. To assist you with that, you've got 6 years, if you win that county court judgment, to then collect that money. If you've gone down the section 8 route and money appears on there, on your order, you can apply, certainly using High Court, for a combined writ of control and possession that covers the money. So then you're thinking, what's the chances of recovering that money? Well, if at the outset you obtained bank statements, pay slips, a next of kin address, maybe a guarantor, a description of assets, what vehicle do they drive, do they own it, some really cracking, crucial information like that gives you a much better chance of a successful enforcement of recovery of the money, then okay, yes, there's a chance that it might be worth attempting to recover the money whilst carrying out the eviction. But I must warn you, it does add a few extra days onto when we can actually carry out the eviction. More likely, you would look to carry out the eviction because getting the property back is your priority, and then wait a period of time, we say 3 to 6 months, before carrying out a trace. It's a data trace on individual or individuals that basically checks credit reference agencies like Equifax and Experian. It checks the housing register, it checks voters' roll, things like that. And if it pops up with a positive address, then we can look to enforce that monetary element. And it might be that the tenant's in a better financial position if you were to leave it a little bit longer, 1 year, 2 year, because the statute of limitations says you've got 6 years to try and collect that money. The writ is valid for 12 months. So if you did choose to have a combined writ of possession and control, we can just exercise the possession element to get the property back as quickly as possible. And we could then wait a few months, carry out a trace, and we've still got the same writ and it's valid. It's got the money element on it, and we can exercise enforcing that for no extra cost. As long as it's £600 or over, and we don't need permission such as section 42 to enforce that monetary element. So, highlights and why you're thinking about High Court enforcement, and the number one reason is time scale. MOJ, Ministry of Justice figures, averaged 45 weeks from your start of possession claim to actually claiming back possession of the property. That's over 10 months. Average rent in London, just over £1,500 a month. So going by those figures, you're losing, if they're not paying rent, over £15,000 worth of potential rent. Slightly less outside London, but still a big chunk of money to be losing. So if we can do our bit to try and shave off at least a few weeks, a couple of months at the back end once you've got your possession order, so you're not having to wait for the county court bailiffs 8, 10, sometimes 12 weeks. Because if you've got section 42, upon receipt of the right documentation and the sealed writ of possession, we could carry out the eviction within 2 weeks. That's the highlight. Costs here at the Sheriff's Office start from £295 plus VAT, and we can usually carry out a standard eviction for around that price. There is a couple of other costs to consider, such as your court fees, which you've gone through, and locksmiths, which is just on the next slide, I think. We are personally liable. It's our authorised officer, David Asker, whose name would be on the writ, who is personally liable for the execution of that writ. We've never failed on a writ of possession. If there is going to be resistance, we need to know about it, and we'll get an extra agent to attend. We can carry out risk assessments where required. If there's a breach of the peace, the police are duty bound to assist us in the execution of that writ. We will send a 7-day notice. As soon as we've got the sealed writ, we'll send what's called a notice of possession. We'll organise the date and time that the eviction will be carried out, and it gives the tenant the knowledge that they need to get their bags ready, they need to be ready to leave, because that's when we're turning up. And as I said, quite often they're ready to leave because they're just waiting to be kicked out, so they're a priority for housing. We will assist you with the forms. We will get the writ for you, assist with attempting to recover any outstanding rent. And the torts notice relates to the removal of tenants' goods. You've got to be obviously a little bit careful. Ideally, the tenant takes everything with them during the eviction, but sometimes that's just not possible. So you would, as a landlord, make an arrangement with them within the next 10 to 14 days, date and time for them to come back and collect the rest of their possessions. You can have them outside the property waiting for them to collect if you don't want to let them back in. But a torts notice would be served on any items, bulky or otherwise, that they've left behind, haven't collected, could be dumped, but you just need to be sure. And the torts notice states to the tenant or defendant, the owner, you've got 7 days to collect this, otherwise it'll be suitably removed, and then you can just destroy it or sell it or take it to jumble, whatever, accordingly. So we like to throw this picture in. It was taken during a real possession of a property, and it must have been an aggrieved tenant who had the time and could be bothered to even take the kitchen sink. We've had copper piping taken, we've had boilers taken off the wall, we've turned up and the cooker's gone. But yeah, you know, it just drives it home that the quicker we can help you get these tenants out, sometimes the better. And more of a little summary, really, the last 2 slides for you. Section 42 isn't required on claims against trespassers. It is required against tenants. And if you apply for it on the outset, when you're applying for your original order, then it's not going to cost you anything. You don't need to issue permission to issue the writ if it's against trespassers or mortgagors. The occupant should receive notice of proceedings. We always send notice. That's that 7-day notice. It's good practice. Judges like to see that you're doing that, which we do. Give them sufficient notice that we'll be attending. You should know whether your property's covered over the Rents Act or not. Not a lot are nowadays. And then final slide. If there is going to be potential for violence or resistance, let us know. We can get the right amount of officers or agents attending, but we also might be able to dispense with the application to notice, to let them know that we are applying for the writs, attending date and time, just to take them by surprise. Locksmiths is another cost to consider, and I'm sure that we're no different to any other High Court enforcement company in that we use locksmiths all the time. So we've got certain ones on contract, which are usually going to be more cost effective for you than certainly plucking one off the high street. But the cost depends upon the type of locks, the number of locks, the number of doors where locks need changing. So just bear that in mind. We've got a tracing service, £45 plus VAT, no trace, no fee. Wait at least 3 to 6 months for your tenant to put down roots and let them start applying for credit, put their name down on the voters' roll, housing register, that type of thing. You've got 6 years to enforce the monetary element, so quite often it's futile trying to do it when you're actually carrying out the eviction. Getting the property back is the most important thing, so that could be done at a later date. The writ's valid for 12 months. And then finally, security. If the property is going to be empty for a period of time after the eviction, it's definitely worth thinking about steel shutters or CCTV or man guarding, something along those lines, especially if there's a risk of re-entry if you've got an aggrieved tenant, something like that. You will be getting a copy of the slides. Any questions, please do fire them in. Thank you.
Thanks very much, Matt. We will have a final learning review, and then we will endeavour to answer at least 1 or 2 questions that have been coming in. These slides and this recording will be distributed to everyone who has attended the webinar today, so don't worry, you'll be able to receive those tomorrow at some point. So let's launch the final couple of learning review questions. They should be popping up on your screen now. And the first one is, how many days notice will a High Court enforcement officer give? 14, 7 or 30 days? And the correct answer is 7 days. Okay. Under application for Section 42, the eviction cost will be paid for by the landlord, the tenant, or the tenant's deposit. And yes, most of you have correctly answered that with the landlord. And you can recover rent arrears using a CCJ at the same time as a possession order. Is that true or false? That is, of course, true. And I'm about to launch our final poll. And why might it be beneficial to use High Court enforcement instead of the County Court bailiff? And the answer is, of course, all of those reasons will apply. Right, so over to our first question. I think this one is for Yez. Yes, can you give some examples of prohibited payments?
Yeah, sure. So it's mostly to do with tenancy startup fees, third-party costs, so such things like viewing costs, which ordinarily a landlord might have wanted to pass on, inventory check-in and check-out fees, cleaning costs. It's quite common that you'll see in tenancy agreements that the tenant is required to pay for professional cleaning at the end of a tenancy. That will be a prohibited cost now, and things like credit checks or any other third-party costs.
Okay, another question for you, Yes. Can both the Section 21 form and the Section 8 form be served together, or is it a choice between either or?
We often serve a Section 8 and a Section 21 together because a lot of the time, if the tenant is in breach, and particularly if you think that that breach is capable of being remedied, but by that point the landlord has decided that they want to evict, we might serve a Section 8 notice, because it's going to be quicker to, if they don't remedy that breach, to be able to issue court proceedings. But we would then, on a without prejudice basis to that notice, serve a Section 21. So yeah, we do that often. They can be served at the same time. You just got to decide before you issue county court proceedings which notice you want to rely upon.
Okay, and a question here from Matt. If a CCJ for £10,000 was issued in 2013, can it still be referred to the High Court for enforcement?
No, only because we're near the end. You could renew it, however, if you would use an N244 application notice to vary the judgment, but you do need to evidence what you've done in the last 6 years, which is your statute of limitations to enforce that. What have you done in those 6 years to try and recover the money? If you can evidence that you have made some unsuccessful attempts, then the judge may well issue another 6 years.
Okay, and we have a comment here. How to rent only applies to tenancies which commenced on or after the 1st of October 2015. Yes, is that?
So the legislation suggests, but it's not entirely clear, that the requirement to provide the tenant with the how to rent booklet doesn't apply to ASTs granted before the 1st of October 2015. However, all of the guidance suggests that it's best practice to do so before you do serve a Section 21. So we have been advising our clients to serve.
Okay, and another question for you, Yes. If a Section 21 notice is served personally rather than by registered post as per the tenancy agreement, does that become an invalid service?
It all depends on what the tenancy agreement says. So if the tenancy agreement provides that personal service is permitted, what you'd normally need to do is provide a certificate of service to the court confirming that you have personally served it, and that is usually sufficient for service purposes.
Okay, and a question here for you, Yes, about tenancy deposits. If the deposit was registered late but returned at the end of the tenancy, is the landlord still liable for a penalty?
Unfortunately, yes, but that's subject to the tenant knowing their rights and bringing a claim. And if they do bring a claim, provided that there was non-compliance, the court does have to make an order. It's usually once, twice or 3 times the deposit amount, and the amount of the penalty. I do find that if you've come to the end of the deposit's been repaid to the tenant in full, the tenant hasn't actually suffered any loss, you might find that the landlord is liable to pay a penalty of, say, 1 times the deposit amount.
Okay, and please do keep coming with those questions. If you have any questions that you'd like either Yes or Matt to answer, then we will be ensuring that we answer these questions in a couple of newsletter articles coming up over the next few weeks. We do have another question. Bear with me 1 second, it's just come through.
No, you would, right.
Let me just read that question out so that you all know what we're answering there. If a writ is valid 12 months, do we need to renew if they are paying over a few years? So if there's a payment agreement in place?
No, you don't. It's a short answer. And if they were to stop paying after the 12 months, there's a caveat actually in the regulations that says the writ is renewed and you get another 12 months. So yeah, it's okay to extend payment arrangements over those beyond 12 months.
Okay, wonderful. Well, I'd like to thank you both for taking part in this webinar today. I'm sure it's been incredibly useful for all you landlords out there. Again, I'll make sure that these slides and the recording are distributed tomorrow, so you should receive those around this time tomorrow, and that will be an email that may go to your junk. So if you don't receive it, do check your junk folder, please. Thanks very much, everyone, for attending the webinar today, and yes, we'll be holding our next webinar next